Remain seated for a moment, Mr. Chappell. You have been convicted by a jury after a trial of one offence of manslaughter. At the beginning of September 2023, you went to the New Brogden public house in Porthcawl. Daniel Bradley was also there, as he was a regular customer at that pub. You were not. Mr. Bradley got into conversation with a woman who was with you. You became annoyed at him and said to him to come outside. Miss Brown, who worked there and knew Mr. Bradley, calmed the situation by pretending to be Mr. Bradley's girlfriend. It was about a week later, on the evening of the 8th of September 2023, that Mr. Bradley was again in the New Brogden public house. He was having a few beers, chatting to people that he knew, dancing with his ex-girlfriend and having a good time. You also returned to the New Brogden public house that night, together with your girlfriend. By about 1:45, Mr. Bradley, his ex-girlfriend Miss Mackay, you and your partner Miss Chappell were outside the pub. From the CCTV it can be seen that there was some interaction between the four of you which continued on and off for some time. At about 1:20 in the morning, you, your partner Miss Chappell, Mr. Bradley and Miss Mackay were in the lane alongside the New Brogden pub. You were behaving aggressively towards Mr. Bradley, swearing and squaring up to him. You were angry with him because you mistakenly claimed that Mr. Bradley owed money to your girlfriend. Mr. Bradley was described by a witness as being quite timid and shy throughout. You punched Mr. Bradley 2 or 3 times in the face, causing him to go to the floor until he did not get up. You and Miss Chappell then walked away up the lane in the direction of Nichols Avenue. Mr. Bradley got up then, and he and Miss Mackay walked in the same direction.
Buckle up, guys. Today we are going to hear a sentencing that begins with a pub argument and ends in irreversible loss. The court recalls how a brief confrontation turned violent, punches thrown, a man knocked down. The trouble seemed over, but it wasn't. What looked like a finished scuffle was only the opening chapter in a chain of aggression that would soon spiral far beyond a late-night dispute.
The incident was over. You had walked some distance away, but you were not prepared to leave it there. You deliberately walked back to confront Mr. Bradley again. Mr. Bradley was trying to get away from you. Miss Mackay tried her best to protect Mr. Bradley as you then launched a vicious attack on him, despite the fact that you had a surgical boot on your right leg. This assault was captured on CCTV. It included kicking Mr. Bradley to the head area and also to the upper part of his body when he was on the floor. Mr. Bradley, who was just 5 foot 5 inches tall and 9 stone 2 pounds, was in a very vulnerable position and utterly unable to defend himself. Eventually, you walked away and Mr. Bradley was able to get up, and he and Miss Mackay left the area. You went to the flat of an acquaintance where you told people that you had assaulted Mr. Bradley. You were described as bragging about it. When asked why you'd done it, you claimed that Mr. Bradley had said something about your girlfriend. Mr. Bradley suffered bruising, a bloody nose and a broken rib. Photographs of the bruising are on the digital case system. The evidence of Professor Lyon, a medical expert, was that a significant amount of force is needed to break the rib of a young adult male. On the 11th of September, Mr. Bradley's mother visited him at his home address. He was battered and bruised. His nose was still bleeding intermittently. He was in considerable pain from the broken rib and was having difficulty in breathing as a result. He went to hospital, where he was diagnosed with a broken rib, given appropriate advice and discharged home, which was the proper medical treatment. Over the next few days, Mr. Bradley developed a chest infection as a complication of the broken rib. By the 15th of September, he was seriously unwell and suffering from severe sepsis. He was taken to hospital.
As an observer, the escalation is stark. The defendant returns, anger reignited, while the victim tries to leave. A vicious assault follows, kicks to the head and body as the man lies on the ground, vulnerable and unable to defend himself. Days later, injuries lead to infection, sepsis, organ failure, and ultimately death. The violence and the fatal outcome become inseparably linked.
The sepsis caused multi-organ failure and cardiac arrest, causing irreversible brain damage because of the lack of oxygen to the brain when his heart was not beating. Daniel Bradley died at 17:53 hours on the 29th of September 2023. He was just 32 years old. Victim personal statements from Mr. Bradley's parents have been read to the court. I won't repeat the contents, but I take it all into account. You have caused terrible grief and immeasurable pain that cannot be healed. You are still only 29 years old. You have appeared before the courts on 8 occasions for a total of 17 offences, of which 4 were offences against the person. Your first conviction was for assault occasioning actual bodily harm when you were made subject to a referral order by the Glamorgan Valleys Youth Court on the 7th of March 2012. That was an incident where there was a verbal altercation in the street between the victim and one of a group of youths who punched the victim. You then ran over and yourself punched the victim to the right side of his jaw, causing soreness. You dragged him to the floor, and whilst he was on the floor, you and 3 other youths kicked him, causing soreness to his upper body. On the 16th of April 2021, you appeared before the Merthyr Tydfil Crown Court. For the offence of assault occasioning actual bodily harm, you were sentenced to a term of 12 months imprisonment. You were also sentenced to concurrent terms of 1 month each for possession of cannabis and criminal damage. That was a domestic violence incident. You attended the address of the victim, your partner, after you'd had a verbal argument. You repeatedly punched her to the face area, causing severe bruising, bleeding and swelling to the eye, head, mouth and cheek areas. You grabbed her by the hair, pulling her back from fleeing for safety, and she had a coffee table thrown at her and was hit by some wood. On the 22nd of November 2021, you were sentenced to a total term of 18 weeks imprisonment for a number of offences: driving whilst disqualified, no insurance, failing to provide a specimen for analysis and possession of cannabis. But you were also sentenced for an offence of assault by beating of an emergency worker. That was when you spat at a police constable.
Previous convictions for assaults, domestic violence and attacks on others form a pattern, not an isolated lapse. The judge places this case within sentencing guidelines for unlawful act manslaughter, deciding the culpability is high. The repeated blows, the force used, and the decision to return and attack again show intent to cause serious harm, pushing the offence firmly into a more severe category.
Whilst you were under arrest. Then on the 3rd of December 2022, on the 22nd of December 2022, you were sentenced to a total term of 8 weeks imprisonment for criminal damage and possession of a Class B controlled drug and an offence of battery. This again was another domestic violence incident. The battery was when you pushed your partner to the floor and kicked her to the legs and to her ribs. I have taken into account the definitive sentencing guideline on the imposition of community and custodial sentences. I've also taken into account and applied the sentencing guideline for unlawful act manslaughter. I'm satisfied that this is a case of high culpability category B. Death was caused in the course of an unlawful act which involved an intention by the offender to cause harm falling just short of GBH. I have come to that conclusion because of the number and nature of the blows that you inflicted on Mr. Bradley, and in particular the fact that you kicked Mr. Bradley very forcibly whilst he was in a very vulnerable position on the floor. The nature of the injuries caused, in my judgment, is of little assistance in assessing your intent. This is not, as submitted by the defence, on the cusp of categories B and C. It is a category B offence. The harm caused is obviously of the utmost seriousness, and the loss of life is taken into account in the sentencing levels in the guideline. For a category B offence, the recommended starting point after trial, without allowing for aggravating or mitigating factors, is one of 12 years custody, with a range of 8 to 16 years custody. There are a number of factors increasing seriousness. You have previous convictions for violence. You were under the influence of alcohol and drugs. This was persistent violence. It has been submitted on your behalf that it was not persistent because both parts of the assault were brief. That is evidence that the incident was not prolonged, which is clearly correct. But this was persistent violence as you returned twice. There was a lack of premeditation for the first part of the assault, although there was clearly premeditation when you walked back to assault Mr. Bradley on the final and ultimately fatal occasion. You were subject to post-sentence supervision at the time. I turn then to the factors that are said to reduce seriousness or reflect personal mitigation. It is submitted on your behalf that you feel remorse. You told your then probation officer that you did not want Mr. Bradley to die, and you said that you were very emotional. You told the probation officer who wrote the pre-sentence report that you took it too far, expressing regret for the extent of your assault, but not recognising that you shouldn't have assaulted Mr. Bradley at all. When you expressed emotions, it was to think of your children, not Mr. Bradley's children, and how your children would feel if you had been the victim.
Substance use, persistent violence, and offending while under supervision increase seriousness. Claimed remorse is examined but found limited, focused more on personal consequences than the victim. As an outside observer, the court's concern is future risk. Reports describe minimization, blame shifting, and a failure to grasp the danger posed, leading to a formal finding that the defendant presents a significant ongoing risk to the public.
In the pre-sentence report, it states, Mr. Chappell accepts responsibility for the actions that led to the victim's death. He expressed that, had he been provided the opportunity to plead guilty to manslaughter, he would have done so at the earliest possible opportunity. I have been told that this was because there were discussions about whether a plea to manslaughter would be acceptable to the prosecution, and that it was not. However, it was always open to you to accept responsibility for Mr. Bradley's death and to plead guilty to manslaughter. That is not an aggravating factor, but in my judgment, and when taken together with the contents of the pre-sentence report, it shows that you are not truly remorseful. I have taken account of the contents of the pre-sentence report, all the contents of the sentencing notes submitted on your behalf, and of course the mitigation advanced very ably on your behalf by Mr. Rauch King's counsel today. Now, there was nothing more that he could have said to assist you. I turn then to the assessment of dangerousness. I am satisfied that there is a significant risk that you will commit further specified offences, and that by doing so you will cause serious physical or psychological harm to another. I have come to that decision for the following reasons. The nature and circumstances of this offence. Your previous convictions for violence. It's been suggested on your behalf that they were less serious and different because they were committed on your partners, but those differences, in my judgment, carry very little weight. I take into account your poor compliance with court orders, your drug and alcohol misuse, and all the contents of the pre-sentence report. You are a man with a long history of violence. You minimise and justify your violent behaviour, and you try to blame others. The probation officer states in the pre-sentence report, Mr. Chappell's indexed offence evidences a risk to members of the public. It appears that Mr. Chappell has utilised his same victim mentality when discussing this incident, stating that he felt ripped off and taken advantage of, and sought retribution for this. Mr. Chappell once again described that he was not an angry or violent person, however could not justify why he used such excessive levels of force in attacking the victim. It is clear that you do not recognise the risk that you pose to others. Stand up, please. Obviously, only an immediate custodial sentence is appropriate in this case. I have considered whether a standard determinate sentence is appropriate. If imposing such a sentence, the least period of detention I would have imposed in all the circumstances after trial would have been one of 14 years imprisonment. Such a sentence would not fully address the risk you currently represent, and I consider it necessary to impose an extended sentence in order to protect the public in future. The extended sentence is made up of two parts: a custodial period that will be no longer than the 14 years that I mentioned, and an extended licence period of 2 years, making an extended sentence of 16 years duration in total. In determining the extension period, I have taken into account the persistence of your violent conduct over the years, all the contents of the pre-sentence report, and the serious nature of the future risk to others. You will serve 2/3 of the custodial period before the parole board will consider whether it is safe to release you, and if so, on what terms. Once released, you will serve on licence any part of the custodial period which remains, and you will then be subject to an extended licence for a further period of 2 years. If you commit another offence when you are subject to licence, or you fail to comply with the terms of your release, you are liable to be recalled to custody, and you may serve the entire sentence in custody. The days which you have already spent on remand in custody will automatically count towards the custodial term of your sentence. If the statutory surcharge applies, the order can be drawn up in the appropriate amount, and any error can be corrected administratively, as can any error in the collection order that I also make. Finally, To the family of Mr. Bradley, I know that sentence cannot ease the terrible grief that you are suffering, and it's not intended to reflect the value of Daniel's life, because that, of course, is beyond measure. It's clear that he was very precious to you all, and he was dearly loved, not only by his family, but by all who knew him. In addition to the terrible grief that you are suffering, you've had to cope with these proceedings. You have done so with patience and dignity. Thank you. The court offers its sincere condolences to you.
The sentence is delivered with finality. A standard term is ruled insufficient to manage the risk, so an extended sentence is imposed, a lengthy custodial period followed by extra years on license to protect the public. Release will depend on parole assessment, with strict conditions and recall powers. The hearing closes with words to the family, acknowledging their grief and dignity. Like the video, subscribe to the channel, and we'll see you in the next video.